So the question was asked within Chapter 4 of the textbook, what does the Establishment Clause mean? And specifically, Congress shall make no law respecting an establishment of religion. Now, this is important to know that at the beginning of the First Amendment, it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And when we get into specifically Wheel's book about the First Amendment and about the various liberties and fundamental freedoms that Americans have protected against government intervention, we will talk about this first religion clause that basically says government cannot adopt an official religion. It can't support a religious venue by establishing that particular religion over others. That's how we get the Establishment Clause as the name of this particular section of the First Amendment. Now, the Establishment Clause is designed to basically protect one against government favoring one religion over others. Before the revolution, with the use of the British monarchy over the American colonies, the British government supported the Anglican Church, the Episcopal Church, is what we call here in the United States. Whether you were Catholic, whether you were Presbyterian, whether you were Methodist, your tax money went to support the Church of England. When the Bill of Rights was established and debated, it was believed that that kind of governmental favoritism did not need to be part of government in terms of favoring one religion over the other. And so the idea that government cannot favor a religion doesn't mean that government can't be involved in religion. And government has been allowed to be involved in religious activities and associations, primarily through things like private religious schools when it comes to funding and supplies. For students who attend private religious schools, the court, specifically the U.S. Supreme Court, has held that they can receive state monies as well as supplies if it goes to the benefit of the student and not to the benefit of the private religious school. Now, that may seem contradictory if indeed a student is paying to go to a private religious school and thereby using state funding and supplies, but the court has said that the money goes to the student. The student can do with that money what he or she wants to do. Another area that government has been involved with when it comes to religion is government prayer before legislative meetings. Before the U.S. House or the U.S. Senate begins its daily sessions, there is oftentimes a prayer that is done for the benefit of the members of that chamber. In addition, state legislative chambers, state houses, state senates, even city councils, county commissions open their meetings with a moment of prayer. Now, the prayers must meet certain conditions and criteria in order to be legal in the face of the U.S. Constitution. And in fact, there was a huge case coming out of Rowan County here in North Carolina dealing with this very issue, that the county commissions had to change the way that they went about doing their prayers before their legislative meetings, because otherwise it would violate the U.S. Constitution. Now, when it comes to the second religion clause, that's the idea when it comes to the free exercise, that government can't interfere with one's exercising religious practices or beliefs. This is known as the free exercise clause. And what you see is that this particular approach is designed to protect an individual's rights to believe what they would, but also to practice their own religious faiths and practices. Now, the government cannot inhibit or deny religious practices, but again, like with the Establishment Clause, it is not absolute. Things like bigamy, things like peyote use, the use of what would generally be considered illegal drugs, cannot be used during a religious service. Those kinds of conceivably religious practices can be. Now, both of these clauses have been applied to the states through the 14th Amendment's incorporation. We talked a little bit about this in a previous video regarding the use of the 14th Amendment and the process of bringing in the various components of the Bill of Rights to apply against the states. What was interesting, before the 14th Amendment's incorporation of these particular parts of the First Amendment, some states had actually had an official religion. The state of South Carolina had designated the Anglican Church as being the state's official religion. It can no longer do that based on the 14th Amendment from the First Amendment's religion clauses.